Well, hello and welcome to this session on advanced care planning definitions. My name's Anne Meller and I'm a nurse consultant in advanced care planning at Prince of Wales. I'd like to acknowledge the traditional custodians of this land, the Bidjigal tribe, who are part of the Eora Nation. I extend my respect to elders, both past and present, and to all Aboriginal people present. Today I'm just going to cover some definitions, which is really important for advanced care planning. So advanced care planning, what it is, what's an advanced care plan, what's a plan versus a directive, and also enduring guardianship, which is very important. So what is advanced care planning? You'll probably have your own ideas about what that is, but what I'm just putting up for you now on the slide is basically from a national definitions perspective from the national framework that was developed in 2011. So it's basically a process, and we've got to be very careful about the process of advanced care planning so that we can ensure that the patient's wishes are heard and that they can provide us with some ideas about what they want in terms of care and treatment should the time come when they can't speak for themselves. So what is an advanced care planning? After you've been through the process and you've been talking with people who are important to you and close to you, who can give you good health information, to people who might be called upon to make decisions if you can't do that for yourself, you might end up developing an advanced care plan. So basically an advanced care plan, it just states your preferences about health and personal care and preferred health outcomes. What I'd like to note is that an advanced care plan might be done by someone who's competent and able to just give some guidance, or it might be done with support from somebody else, such as if they can't read that well, or their vision's impaired, or their handwriting's is limited, or it might be done on behalf of a person altogether. So that person might not have that competence and ability to make really clear instructions. So a plan is going to provide guidance in the event that the person can't provide that direction for themselves. An advanced care directive is a more formal way of recognising those advanced care planning discussions that we have. So it's a written document, it's recognised by common law, and it's might be authorised by legislation. Now this is a national framework definition, and so it's authorised. We don't have legislation for that in New South Wales for directives, but the next point is that we do have legislation about appointing someone. So nationally it's perceived that if you appoint someone to make your decisions for you and or you write an advanced care directive for yourself, those would both constitute an advanced care directive. So the common law supports the directive part, and enduring guardianship is covered in New South Wales legislation. That's when you appoint a substitute decision maker. So therefore in New South Wales you have two options when you're planning ahead. You can appoint someone to make your health and lifestyle decisions, and that person's called an enduring guardian. Within that appointment you might include directions about treatment, and or you might provide an advanced care plan, a statement, a letter to them, or you might go on to do an advanced care directive. So in terms of enduring guardianship, a lot of people confuse this with power of attorney. So power of attorney only relates to appointing someone who can make decisions relating to money, real estate, shares and property. So a family or friend might advise you that they're the power of attorney or they're the enduring power of attorney, but that only helps when it comes to paying bills, selling real estate, making share transactions, etc. The authority doesn't extend to health and lifestyle decisions. So what's an enduring guardian? So an enduring guardian is a person you appoint to make health and lifestyle decisions in the event that you're unable to make those decisions for yourself. Guardians can make decisions which are called functions about where you live, what healthcare services you receive, what services, as in community services, can assist you at home, and they can give or withhold consent to medical treatment on your behalf. You can appoint one or more enduring guardians with specific functions. You might have a primary guardian who's appointed, and if they're away, there's an alternative person who can step in. Or you might have a couple of people that you want to make decisions together and or separately, or severally as it's called. And within that appointment, as I mentioned before, you can add directions or limitations in the appointment. You would sign that, the guardians sign that they accept that appointment, and those signatures need to be witnessed by an eligible witness who's a legal practitioner, not a JP. You'll be glad to know that guardians can't make a will or alter one on your behalf. They can't vote or consent to marriage on your behalf. They can't override your objection to treatment, and they can't consent to special treatment. In those circumstances, the treating practitioner must apply to the New South Wales Civil Administration Tribunal, NCAT, the Guardianship Division, for consent to the treatment. Guardians also can't make decisions that are contrary to the law. It's important to note that if you look at one of those guardianship appointments, you might find directions in that appointment. So I'll just let you read through the next couple of slides where patients have included in the appointment what directions they want to have in regards to the use of life-sustaining treatment. So while a guardian can consent to treatment, patients might actually refuse treatment at a specific time when they can't speak for themselves, and the guardian is bound by those decisions. It's quite common to see in many guardianship appointments that there are 4 clauses. People can write their own, but often solicitors have templates that they work from. So someone might have an incurable or an irreversible illness, but we'd need to determine, are they in the terminal phase of that prior to acting on the wishes described. So the patient might then go on to say that they want the guardian to then refuse treatment, even if that's going to prolong their life, and they might die as a result if that treatment's refused. And then they might outline the types of things they do or do not want at that point, including life support, ventilation, artificial nutrition and hydration, and CPR. So it's very important that we look for directions in enduring guardianship appointments where we have them. So in terms of guardianship, someone might be appointed by the New South Wales Civil Administration Tribunal. We should try and get a copy of that appointment to know what functions the guardian has, and also get copies of enduring guardianship from patients where we have them. So of course that instructs us as health professionals who to obtain consent from if the person's incapable, and it applies when the person can't speak for themselves. In a national prevalence study in 2018, 27% of people who had appointed a substitute decision maker actually included directions regarding the use of life-sustaining treatment. So it's important to try and capture that. I'll now go on to advanced care directives. So there's no prescribed or set form in New South Wales. People can write this on whichever format they choose themselves. So an advanced care directive, one document that we've used in our district has been the Making an Advanced Care Directive for New South Wales Health. It's revised, it's available online. You can obtain hard copies via the Better Health Centre. So the documentation standards for an advanced care directive to be valid in New South Wales, it must be written by the person who was voluntarily by a capable adult. It needs to be clear and unambiguous, and it needs to extend to the circumstances at hand. And a witness isn't mandatory, but it's certainly more persuasive, and it's certainly the path that New South Wales Health has gone down in the Making an Advanced Care Directive template. We've had 2 cases that have gone to New South Wales Supreme Court. Hunter New England Health Service has taken documents written by patients to the courts to actually get them validated by the judge to follow the instructions within those appointments. And we could now say that as a judge has ruled on those appointments, that advanced care directives, if they meet the validity requirements, are legally binding. Therefore, in New South Wales, we know practitioners require valid consent. Capable patients have the right to refuse treatment and can do that in advance. And the Guardianship Act provides a safety mechanism for people who can't provide their own consent to treatment. New South Wales Health has several guidelines around end-of-life care and using advanced care directives, and more recently they have updated the Consent to Medical and Healthcare Treatment Manual, and that's a mandatory policy for New South Wales health professionals. So advanced care plan, as I said in the definitions, they might be done by the person, with the person, together with to support a person, or they might be done on their behalf. Therefore, advanced care plans need closer inspection. They might be done by someone when they're capable and they're just going to provide us with some guidance. They're not necessarily instructional. They tend to include values and preferences, and if there are treatment refusals included within that document, then it might be interpreted as a directive. So a note regarding any capacity concerns, if any, might be useful. If they're done with or by the person responsible, and capacity can fluctuate or it might be lacking irreversible. So they probably shouldn't be including any treatment refusals if the person's not appointed as a guardian with a health service function. So in a nutshell, if you get a document in front of you and you don't know whether it's a directive or a plan, if you can say, yes, I've got no concerns that the patient was capable when they signed it, it's specific, it relates to the situation at hand, it's current, they haven't changed their mind, perhaps it's witnessed, then you can probably say, well, yes, this is a directive and we should follow this. Or if from what you're reading, it's a document of a consensus discussion and it's guiding decision making, I'd classify that as a plan. So some patients just want to write a letter and formalise their health conditions and what's important to them in their life, and I'll document that as a plan, more as a narrative. But if it gets to a point where they say, I'm at a point in my life, I've had a good innings, I don't want to have CPR, they're very worried about CPR, I don't want to have CPR because I'm at a certain age. If they start saying that, then I would include that and call that an advanced care directive because they're actually refusing a treatment. So we need to pay attention to at what point that's refused. For the person responsible, if they're just been involved in decision making and wanting to support the person, in our district we do have a statement of values and wishes form, and that can be completed by the person responsible, but there's no treatment refusal included in that. So check your EMR flow sheet. In the flow sheet you'll see the Advanced Care Documents tab. It includes advanced care directives, advanced care plans, enduring and other guardianship appointments, as well as ambulance plans and the ad hoc record of discussion. If you want some more information, you can go to the Planning Ahead Tools site. That's the New South Wales portal for advanced care planning. And in that, you'll see up in the top right corner, there's legal resources for health professionals. That's the health law link, and that will take you to end-of-life decisions, the law and clinical practice. It's really worth having a look at that. If there's any other questions, feel free to email me. Thanks very much.